Good afternoon. I'm Sandy Lozo, RCMA's Practice Support Liaison. Thank you for joining us today for our annual employment law update. I would love to introduce you to today's presenters, Attorney Pamela Thakur and Associate Attorney Alexia Perron from Thakur Law Firm.
Before we get started, we'll just provide a general disclaimer here, which is that we are providing information here for educational purposes. Medical practices should decide what's most appropriate for them. And it's informational, so nothing in here is creating an attorney-client relationship. So let's get started. So today we do have a number of different topics that we're going to discuss. First, we will discuss the minimum wage increases as well as the healthcare worker minimum wage and the difference between the two. Then we will discuss new leaves of absence laws, updates to discrimination, harassment, and retaliation laws, workplace safety, workplace posters and notifications, the Private Attorney General's Act and updates to independent contractors, as well as disclosures for disclosures, requirements for health service plans. And finally, we will discuss recent case decisions. So the minimum wage increase and the healthcare worker minimum wage. So for California, the minimum wage has been increased. Give me 1 second here. Effective January 1st of 2025, the minimum wage is now $16.50 per hour. It was previously $16 per hour last year. It was raised by 50 cents to accommodate inflation of 3.18%. So there are different requirements for different cities and counties that require more than $16.50 per hour. It does not apply to Riverside County or San Bernardino County. And if you have any exempt employees, so exempt employees would include managers, physicians. These would be the individuals that would qualify to be under the executive, administrative, or professional exemptions. Then the minimum exempt salary for those employees is now increased to $68,640 per year. So if you do have exempt employees and you have a practice that has less than 25 employees, then these new laws would apply to you. And I'll talk about the healthcare minimum wage requirements as well, and what type of facilities qualify for that, because the minimum wage is higher for those types of facilities. So under Senate Bill 525, this law for minimum wage for healthcare workers went into effect. And basically, it established a series of minimum wage increases over time, an incremental rate of increase over time for certain facilities that are considered covered employees and covered facilities. So the goal of the statute is to increase the minimum wage through various timelines based on the type of healthcare facility and its characteristics. The covered employees and facilities, it applies to a broad range of healthcare workers, including those that are providing direct patient care and those supporting healthcare services. So covered facilities encompass various healthcare settings, including medical practices, hospitals, and clinics. There is a waiver that is allowed for certain clinics facing financial challenges to request a 12-month delay in implementing the new minimum wage requirements. And there's a moratorium for 10 years that would set a different wage and compensation. So in terms of who qualifies for this, it is for certain healthcare facilities, as well as any facility that provides certain healthcare services. So the key here is if you have a medical practice, if you have less than 25 physicians in your group, then you would not be considered a covered healthcare facility, meaning that the minimum wage requirements would be the one that is for $16.50, not for the one under the healthcare minimum wage under this new bill. So healthcare facilities that would be part of this include hospitals, hospital systems, clinics, residential care facilities, and certain outpatient facilities. In terms of independent contractors, this also covers independent contractors who would provide healthcare services or for any healthcare facility, either directly or indirectly, that exercises control over a contractor's wages, hours, or working conditions. And employees under this law would include the following: nurses, physicians, caregivers, medical residents, interns, fellows, patient care technicians, janitors, housekeepers, groundskeepers, guards, clerical workers, and so forth, medical billing personnel, schedulers, anyone working in that healthcare facility, essentially. However, there is one exception to this. This does not include outside salespersons. So that is the only exception here. And if there is an exempt employee that would fall under that category, so if you have a medical practice with 25 or more employees, then they must have a salary which is no less than 150% of the healthcare worker minimum wage, or 200% of the standard state minimum wage. So whichever is greater is the amount it would be in order to be considered an exempt employee. So this means anyone who's a manager or a professional, such as a physician. Now, there is a schedule, an incremental schedule that went into effect on October 16th of 2024 of this past year. And up until June 30th of 2026, hourly employees would be those making $21 per hour. So this is, of course, higher than what the state minimum wage is of $16.50 per hour. So it's very, very critical that you determine whether or not you fall under this exemption. And if you do, to make sure that you give proper notices under the labor code to your employees of their increased hourly rate or their exempt salary rate. And for any other healthcare facilities other than clinics that would qualify, there is a schedule as well, which is a similar schedule. It's important to note that this is increased over time in terms of what the hourly minimum wage would be. So starting on July 1st of 2026 to June 30th of 2027, it goes up to $23 per hour. And then the salary basis would be, for exempt employees, $71,760 per hour. So the key takeaways here are to determine whether or not the facility, your medical practice, would need to comply with the healthcare workers minimum wage or with the regular state minimum wage. And if you cannot afford it, there is a waiver application. The application can be accessed directly from the DIR website. So the action items would be to evaluate how you would fall into either category. Also update minimum wage posters, advise employees of the new rates, provide information to management as well, and make sure that you follow the exemption threshold exemptions as well. All right, Alexia?
So there's been some new laws regarding absence laws, and I'll go through them today. So effective as of this month on January 1st, 2025, there used to be a requirement that you had to use up the 2 weeks of vacation earned. However, the new law that just came into effect is that that is no longer a requirement, meaning that employers can no longer force an employee to use up to 2 weeks of earned vacation time, but unused vacation before accessing paid family leave benefits. This was a condition prior to this year for employees to use prior to receiving temporary disability benefits. And it's important to note that PFL insurance benefits are paid by the state or the employer if the company has an approved voluntary plan that applies in lieu of the state program. So it's just something to keep in mind as to handbooks. And there has now been a new addition as well as expanded leave protections for victims of violence. Now, employees who are victims and the caveat of this law is that it also includes family members who were or are victims of a qualifying act of violence that are protected against discrimination or retaliation for taking time off. And this can include going with them or you going to a TRO hearing, meaning a temporary restraining order hearing, or seeking medical, psychological, or mental health services. So if you're trying to access those services or you're trying to access those benefits to you, then that you can take time off and you can't be penalized by your employer for using that time off. And additional protections include, again, that employers cannot discriminate against an employee for taking time off for jury service, to appear in court, or witness under a court order, or to take time off as a victim of a qualifying act of violence. In addition, just another thing to note is that paid time off, the employee was already entitled to use for this purpose. You can use then paid sick leave or unpaid sick leave to use it in the other ones. So employers will be required to provide written notice of their rights established under this new bill to new hires and all employees annually. So it's important to note that it's kind of a reoccurring thing. And as is kind of seen throughout state and government, the CRD, the Civil Rights Department of California, was mandated to develop and post a form that employers may use to comply with the notice requirement since January 1st, 2025. However, as of today, January 23rd, 2025, the CRD has not yet posted the required notice for victims of violence that employers must provide to their employees. So I'm assuming that they're going to do it this year, but it's something to keep an eye out for. And a lot of times when people think of businesses, they think of big businesses, Fortune 500 or whatever. However, California has now formed a small employer family leave mediation pilot program. And this is for businesses with only 5 to 19 employees that can use this resource to resolve disputes between employees and small employers over violations of family care and medical leave laws. As of January 1st, 2025, it now includes reproductive loss leave. So if it's now included under that they can help small employers resolve those disputes with an employee.
Great, thank you, Alexia. So now we're going to talk about the expanded new laws in California related to discrimination, harassment, and retaliation. So the first one is the Pregnant Workers Fairness Act. So this was actually a regulation that went into effect on June 18th of 2024. So it applies for, going forward this year. So any employer with 15 or more employees is required to provide reasonable accommodations to an employee. An employee's known limitations related to pregnancy, childbirth, or related medical conditions, absent any undue hardship on the operation of the medical practice. So essentially, this is involving any work environment or processes. And in terms of the accommodations, this would include schedule adjustments, telework, light duty, facility modifications, and temporary suspension of essential job functions. There's a new law for 2025, which is very important, related to job applications and postings regarding jobs. So this new law is meant to prevent discrimination against individuals who do not have driver's licenses, and it prohibits employers from including a requirement for a driver's license in job ads, any postings for a job, any applications, or any other employment materials unless one of the following exemptions apply. Number one, the employer reasonably expects driving to be one of the essential job functions of the position. Or number two, the employer reasonably believes that an alternative form of transportation would not be comparable in travel time or cost to the employer. And that would include ride-hailing, taxis, carpooling, or walking. So the key takeaway here is to take a look at any job applications or any postings for jobs and make sure that there is no requirement that the applicant have a driver's license unless it falls under one of these two exemptions. There's also a new expanded law, Senate Bill 1137, that is expanding the protection not just to individually protected characteristics, but any combination of protected characteristics. So essentially, if there are certain protected character examples that are combined, such as national origin, gender identity, race, religion, sexual orientation, or age, there is a protection, not just for an individual protection of protected characteristics, but any combination of these characteristics for an employee to be in a protected class for purposes of prohibiting discrimination, harassment, or retaliation. So the key takeaway here is to make sure that your policies and procedures and your employee handbooks properly reflect the new law that expands the definition to include a combination of protected characteristics as being a protected class. In addition, there's a new law under Senate Bill 399. This is known as the California Worker Freedom from Employer Intimidation Act. So under this new bill, it prohibits employers from subjecting employees to discharge, discrimination, retaliation, or any other adverse action for declining to attend meetings regarding an employer's view about religious or political views. So political matters is defined as broadly as relating to any elections for political office, political parties, legislation, regulation, or the decision to support any political party or labor organization. This also includes topics of union representation. There is an exemption for religious and political organizations that are actually deemed such. And there is a $500 civil penalty per violation, and the labor commissioner can enforce that, or the employee can bring a civil action and seek damages. And if they do that, they can seek statutory attorney's fees if they are the prevailing party. The key takeaway is to make sure your employee handbook reflects this new law. In addition, you want to make sure that you are training your managers about the new law, so that there are no, essentially so that they understand that if there's any discussion whatsoever of any of these topics, that essentially there cannot be any retaliation if any employee is not present for that. In addition to there's a new law under Assembly Bill 1815, and that is the amendment to what is known as the Crown Act. So basically, what this Assembly Bill does is it expands race-based protections in the Crown Act, which is an anti-discrimination provision of the California Fair and Employment Housing Act. So the definition of race now explicitly includes traits associated with the race, including hair texture and protective hairstyles. And that would be defined to include, but not limited to, styles such as braids, locks, and twists. So the term race no longer requires that the traits are historically associated with race, which broadens further protections against any discriminatory or harassment for this protected category. So the takeaway here is that the language has changed in the law. So if there is a definition that includes protection that says historically associated with race, which it was up until last year, that language needs to be removed from your employee handbooks to be compliant with the new 2025 laws. Workplace safety, there are 3 new bills that we'll discuss related to that. The first one is, it will be implemented in March 1st of 2027, but it has come out as of this year. It's called the Workplace Violence Prevention Requirement, where Cal OSHA is adopting standards for hospitals that they must have automatic security mechanisms, devices, or technology to screen for any instruments capable of inflicting death or serious bodily injury. So what this means is that for hospitals, there will be a screening of anyone who enters the hospital to ensure that there are no knives, there are no weapons, there are no guns. And so this is going to be required at the main public entrance, the entrance to the emergency department, and the entrance to the labor and delivery department if it is separate. And they have to assign personnel other than healthcare providers to monitor and operate these devices. In addition, new law that came out this year under Assembly Bill 1976 is requiring first aid kits to have naloxone, so that this would be in any workplaces that have any first aid kits. And then the one that is in effect this year, that is effective January 1st of this year, is Senate Bill 428. And what that does is it expands the ability of employers to obtain temporary restraining orders, TROs, to protect employees from harassment, even when such behavior has not escalated to violence or credible threats of violence. So this is a new expansion. Previously, employers could only ask for TROs or seek them on behalf of their employees if there was actual violence or credible threats of violence. However, Senate Bill 428 has broadened that scope to encompass harassment defined as knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses a person, and that serves no legitimate purpose. So the conduct has to be one that would cause a reasonable person to suffer substantial emotional distress, and it must actually cause such distress. So the employer's authority is now broadened to seek these TROs in order to enhance workplace safety and provide a legal mechanism to address harmful behaviors before they escalate. And so the key takeaway is to be familiar with this policy and potentially update your workplace policies and training policies to ensure compliance, mainly on harassment, preventing harassment to begin with. And there isn't one exclusion. So if there are any acts protected that are constitutionally protected or protected under the NLRA.
Okay, so for workplace posters and notifications, there's been two new laws, AB 1870 and AB 2299. So as to AB 1870, it's just updated workers' comp notice requirements for employers. So AB 1870 adds additional stipulations to California's existing workers' compensation notice requirements that's already taken effect as of January 1st, 2025. And these new notices require that it must include information on employees' rights to consult a licensed attorney for advice on workers' compensation law, and a statement that attorney's fees may be paid from the injured workers award. So existing notice obligations include an informational poster that must be displayed in a conspicuous location frequented by employees, like the break room or where you go heat up your lunch. It also requires new hire pamphlet provided at hiring or end of first pay period, explaining again workers' comp rights and benefits. And as to injury reporting, an employer must provide a workers' comp claim form, which is DWC1, and a notice of potential eligibility within 1 working day of learning about an injury. As to AB 2299, that is a whistleblower notice. So it requires the state labor commissioner to develop a model list of employee rights and responsibilities under existing whistleblower laws. Employers will be required to post this notice beginning again on January 1st, 2025. So it's already in effect. And the notice must be written in a font larger than 14 point. So it can be actually readable and contain the telephone number of the whistleblower hotline. So employers who post this model list will be deemed compliant with existing requirements thereafter.
And I just wanted to add that there are additional posters that are required that you can obtain through various sources, but that would include the new minimum wage requirements, the new expansion of the discrimination laws, and that as well as the leave laws. These posters can be purchased online. But these are very specific new posters that would be in addition to the ones that are currently, the standard posters that you would have with the new hourly minimum wages, as well as the discrimination laws.
So on to Private Attorneys General Act, which is also known as PAGA. This includes AB 2288 and SB 92. So these are just changes to an already existing law, which is known as PAGA. So in 2024, California enacted significant reforms to PAGA through Assembly Bill 2288 and Senate Bill 92, which is collectively now referred to as PAGA 2.0. So these amendments aim to address concerns about the burden of PAGA litigation on businesses while still ensuring that employers comply with labor laws. So under PAGA 2.0, with these new bills, it reduces the penalties for employers so long as they do a proactive compliance. So employers who demonstrate proactive measures to comply with labor laws may receive substantial reductions in PAGA penalties, which as of today is up to 85%. Such measures include conducting regular payroll audits, disseminating lawful written policies, training supervisors on labor code compliance, and just overall taking corrective actions when necessary. So under PAGA 2.0, this also expands cure provisions. The reforms broaden the scope of violations that employers can cure to avoid PAGA penalties. Previously, it was limited to certain wage statement errors, just as if it was a mathematical error and it wasn't something that big of an issue. However, employers can now correct violations such as minimum wage and overtime issues to cure a violation. Employers must rectify the issue and make affected employees whole within 60 days of receiving a PAGA notice. And the amendments also introduced mechanisms for early evaluation and settlement. So no more protracted litigation costs. And again, the overall goal is to foster prompt compliance without overly penalizing the employers. So implications for employers. This just again reiterates the fact that they should be proactive on complying and to encourage them to implement regular audits, update policies, and provide training to supervisors to align with labor code requirements. Just as you see today, there's already new laws in effect as of 2025. So it's, again, really important that you review your handbook and review the notices that are posted up and throughout your workspace, just to ensure that you are complying with those laws. And again, to timely correct violations, you have a 60-day period upon notice to mitigate the potential penalties under PAGA 2.0.
And, you know, we've actually been defending a couple of huge class action PAGA actions. And these cases can be very, very expensive for practices. One is involving a healthcare facility. And the statute of limitations goes back up to 4 years if they allege something called Business and Professions Code 17200. So they can seek damages on behalf of a class. A class is considered 40 employees or more within a 4-year period. And these cases are extremely expensive for employers. And when any client would get hit with this case, there was never an opportunity until this year for them to correct these issues, at least related to PAGA. So if it's a PAGA lawsuit that they receive, it is finally a little bit easier for employers to say, okay, yes, I made a mistake in the past. However, going forward, we're fixing all of our policies, our payroll procedure, timekeeping system, and so forth. And then they can actually go into the settlement conferences, which are now essentially being assisted and mandated by statutory requirement, so that when there's a PAGA action initiated, there is almost like a mandatory settlement conference early on, so that the other side isn't accruing substantial attorney's fees that they're trying to get in addition to the damages for the group of the affected employees. One more thing that I want to mention here is that this is applying to any civil actions that was brought on or after June 19th of 2024. So it is in effect now, and before that time period, plaintiffs could have filed a PAGA action without actually suffering any of those violations. Now they must have been subject and suffered one of those violations that they're alleging the employer committed, and it must be within a 1-year statute of limitations. So that will help employers going forward, as well as if there are any deficiencies in your payroll practices, including missed meal periods, or missed rest periods, or mistakes in the way that the paychecks are written, or the requirements of what needs to be on a paycheck. Those are the types of wage and hour cases that we're talking about here under PAGA that are brought by employees. And previously, that employee didn't even have to be affected with that violation. So this allows employers to really look at their practices and to act swiftly and to cut any potential exposure and damages. So I highly encourage the medical practices to take a look at their employee handbooks, and if need be, update them, and any other payroll practices as well. All right, so there's a new law relating to independent contractors known as Senate Bill 988. Okay, now the question is, does this apply to healthcare professionals? Although it does not specifically apply to healthcare professionals, it would apply to certain third-party vendors that the medical practice is working with. So what does that mean? So it means that if there are any freelance workers for professional services that you're using valued at $250 or more within the last 120 days, then you need to have an agreement in place, a written contract in place that has certain key terms in it. So this could apply to any vendors that you are using for marketing, for any human resources, any graphic designs. So although this does not specifically apply to physicians, surgeons, dentists, podiatrists, or psychologists, it would apply to other third-party vendors that your practice is using. And this is in effect now, January 1st of 2025. It doesn't go back retroactively. So the information you would want is contact information of the parties, list of services, payment deadline, and invoicing, as well as submission date of invoices. I do, however, recommend that if you are employing any physicians or surgeons, podiatrists, psychologists as independent contractors, it is very critical to have a proper independent contractor agreement regardless. The terms that would be in those agreements are quite more substantial than what I would even recommend is required for these third-party vendors. However, if you do have third-party vendors who would fit under these categories, this is a new law that would require an independent contractor agreement with them. So certain other additional obligations would include payment date of the contractor. Employers cannot reduce compensation as a condition for timely payment. Record keeping obligations, and there cannot be any waivers. All right, so now moving on to standard disclosure requirements for health service plans. This is under Assembly Bill 118 and Assembly Bill 1048. So for any healthcare service plans as of this date, they must use standardized templates with uniform terms and definitions for disclosure forms and evidence of coverage. So essentially, there are certain terms, and there is the Department of Managed Healthcare, which develops and issues templates for benefit schedules, cost sharing summaries, and similar documents. And so these master templates and terms must be used. For any dental benefits and rate reviews, any healthcare service plan or health insurer that covers dental services are prohibited from denying any claims related to a patient's pre-existing dental conditions or imposing any arbitrary waiting periods before patients can access their benefits. And the recent case decisions that we're going to go through, there's just a couple of highlights that we want to discuss. One of them is very serious and concerning, and in the sense that this will require employers to really, really make sure that that harassment policies are in your employee handbook, defining exactly what harassment is, because if there is a claim that an employee was harassed, one of the defenses for an employer is to have a policy, a written policy that requires that employee to make a complaint to HR in writing or orally, but it should be something in writing so it's documented, and so that the employer, the medical practice, can initiate an internal investigation and take immediate steps to remedy the situation, which then becomes a defense for any claim that that employee may bring in the future. So there is a case that just came out in 2024. It's called Bailey versus San Francisco District Attorney's Office. And this is a California Supreme Court case. And they had reversed a summary judgment grant for the employer. So the employer won the case, and then the California Supreme Court said, no, you cannot, this is being reversed. And this is the rule currently in California now, because previously, to show that there was harassment, the employee had to show that there was more than one incident. It was not just an isolated incident, but that there was essentially it was a severe, it was persistent, and there were, it just could not be an isolated incident, essentially, in order to show harassment. However, under this new ruling, it holds that an isolated and single use of an unambiguous racial epithet may be sufficiently severe to create a hostile work environment. So previously, in order to show that something was severe and pervasive, it needed to be more than one harassing incident. And in this case, there was a coworker who directed, and this isn't even from a supervisor, it's a fellow coworker who directed a racial slur at the plaintiff, Bailey, which her supervisor later reported, but the personnel officer failed to act upon. And Bailey, so what should have happened is when the supervisor reported it, the employer here, the San Francisco DA's office, should have investigated it and taken some action, either disciplining the individual, the other coworker who made the racial slur, or some type of disciplinary action to remove that individual from the workplace, provide additional training, counseling, writing that individual up, and that didn't occur. So now the California Supreme Court is saying, because that didn't occur, there is liability, and for that one racial slur. So in this case, HR declined to investigate the matter, citing insufficient evidence of harassment or retaliation. And so now, if there's even one incident, it is very, very critical that as a defense to that the employer initiates an investigation, and there are policies in place in the employee handbook on how that should take place. So this California Supreme Court determined that the severity of such conduct has to be evaluated from the perspective of a reasonable person of the same race of the plaintiff. Now moving on to the second case, this does help employers, and it is a case that just came out in 2024, Naranjo versus Spectrum. And basically, this is another California Supreme Court ruling, and it concluded that the employer's objectively reasonable good faith belief that it satisfied wage statement requirements is a defense to claims for penalties or damages for any inaccurate wage statements. So in this case, the plaintiff, Gustavo Naranjo, filed a class action lawsuit against his employer for wage and hour violations, including failure to pay meal period premiums. So if an employee doesn't take an uninterrupted meal break, and that employer is not paid a 1 hour penalty, that employee has an actionable claim for a wage and hour violation. So that's what happened in that case. And he also sought something called waiting time penalties. Waiting time penalties is equal to 30 days of an employee's salary rate of pay. And so that's for the failure to pay those premiums for either missing a meal period or not having an uninterrupted meal period. And the Court of Appeal held that the employer's failure to pay was not willful, and therefore the employer didn't have to pay the waiting time penalties. And in a class action lawsuit, when you're dealing with, let's just say your class is 100 employees, during a 4-year period, and that's pretty low, but assuming you have a mid-sized, practice, or then, 100 employees is a possibility. 30 days of their salary as a waiting time penalty is a very large amount of money as a penalty. So in this case, the California Supreme Court affirmed the appellate court and found that waiting time penalty did not have to apply as long as the employer objectively and reasonably in good faith felt that they satisfied the requirements. So regarding any inaccurate wage statements, and that probably a good faith defense would be having an up-to-date employment policy or handbook that tells the employees that they are required to take their breaks and report if they do miss any meal or rest break, or if it's not interrupted. And that would be a good faith defense. And just a final word. So in terms of the services that we provide for a lot of medical practices, we do assist with handbooks, arbitration agreements, onboarding of employees, helping with separation of employees, representing in pre-lit for any wage and hour or discrimination claims, that they could receive, in any litigation as well, defending if the employer doesn't have insurance, and also in the defense of class action and PAGA lawsuits.